So watching the situation room, coming to you live from our studio here in Accra. I am Sami Wiaf and I'm here with my colleague and friend Fred Tete Ijabon. Today the focus is on the Kpandai constituency, where the Electoral Commission says on the 30th of December 2025 there's going to be a rerun of the 2024 parliamentary election in the Kpandai constituency. It comes on the back of a Tamale High Court ruling that ordered the Electoral Commission to within 30 days rerun elections in the Pandai constituency. The NPP as a political party has vehemently opposed this decision, and the minority in Ghana's parliament is also not happy about this move by the Electoral Commission to conduct fresh elections in the Pandai constituency. Let's get a reaction from the new Patriotic Party, the political party on which tickets the incumbent member of parliament, Martin Dam, is currently on, and what they make of all this, starting from the transmission of the letter from Parliament to the Electoral Commission, the declaration of the seat as vacant by the Electoral Commission, and the rerun of the election in the Pandai constituency. Haruna Mohammed is the Deputy General Secretary in charge of operations for the new Patriotic Party. Haruna, thank you very much for your time. The NPP, many people will say, is not happy about the decision, but they say democracy is expensive, so we should allow the law to work as it is.
Thank you very much, Ami. It's not only the NPP that is not happy. The people of Ghana and the true makers of the law will not be happy with the kind of procedure and precedence that is being set within our democratic dispensation. It is very unfortunate that we are where we are today. Everybody, every well-meaning Ghanaian and any student of law and practitioners of law will be confused at this particular material moment regarding the procedure and the channels in which such profession has been run into. Sami, as you have said, a ruling was delivered by the High Court in Tamale, which the NPP disagreed with the decision of the court and decided to file a notice of appeal and also applied for a stay of execution. This matter was brought to the attention of the Parliament of Ghana, and Parliament of Ghana, in their decision through the Speaker, made reference to the Court of Appeal Rule 1997, CI 19, specifically to Regulation 27(3)A and B. And the Speaker was very specific on the mandatory rule that stated in CI 19, as stated in Regulation 27(3)A. And this is something, it's a trite knowledge that everybody is aware that when a ruling is being delivered, it has a mandatory period of 7 days for it to be implemented or for it to take effect. So within the 7 days, the aggrieved persons or persons who don't agree with the ruling have the right to look at the ruling and to make an application by way of disagreement or an appeal or a stay of execution, which will further be enriched by the CI, which has given the notice of an appeal where such matter may extend the state of execution until the case is determined. So the Speaker made this specific statements, and these were recorded on Hansard. For us to wake up just a day to realize that the Electoral Commission, the Parliament of Ghana through the clerk has written a letter to the Electoral Commission, which has generated the brouhaha in Parliament, which was very unfortunate. The minority did so because the Constitution of Ghana is supreme, and also the laws of Ghana is supreme, and we need to do everything possible to be able to protect the sanctity of our democracy. So we saw that our democracy was being brought down, everything was thrown to the dogs, and we don't know where our country and the rule of law is running to. Again, the pendency of the appeal that has been put in place, and also the stay of execution. Yesterday, we were in court yesterday for the High Court to hear the NPP through the representation of the Director Legal, who was a lawyer for the Pandai MP, which is Honorable Martin Linda. We argued our case in court. We made references to the Manual on Election Adjudication in Ghana, Volume 2, 5th edition, which is captioned as Compendium of Laws from the Judicial Service of Ghana, on which the judge is a member of, because this is a judicial service, where you look at page 17 of that particular manual, it tells you and refers you to PNDC Law 284, specifically Section 18, and it is said that time for presentation of petition in 18.1, an election petition shall be presented within 21 days after the date of the publication in the Gazette of the results of the election, to which it relates. So if it relates to presidential, then if it relates to parliamentary, so it means that in any of the election petitions, this particular CI is the preamble and the base in which you should be filing a petition. So we made this notice to the presiding judge yesterday that because this matter has not been brought to his attention and he was not made known of this particular fact, if he had known the fact before then he would have dismissed the petition before him. And because it was not made to him and he has passed a ruling, the only remedy available to us is for us to appeal and to ask for a stay of execution. And in the laws of Ghana, stay of execution must be necessary and it must be something that is very compelling. So if you see that a wrong precedents were used, defying the laws and logic of the land, and you are asking for a stay because you are going for an appeal, then it is necessary that the judge grants us. When it was time for the lawyers for the NDC, they relied on CI 127 and they mentioned about Regulation 43. And Regulation 42, I was surprised. In fact, I was bleeding within me because the CI 127 is something that I eat and drink every day because it relates to election. And as a member of the new Patriotic Party and from the National Secretary of the party who has been part of electioneering processes, when I read those particular aspects and referred myself back to it, it only talks about declaration and publication of parliamentary results. And if you permit me, it says, subject to Regulation 42. And what is 42 saying? 42 is talking about equal numbers of votes in parliamentary election. Pandai election is not about equal numbers. You are challenging 41 polling stations. And you stated that the difference in there that you are arguing is 500. So it has nothing to do with equal numbers. Then, immediately after the results of the polls for all polling stations in the constituency of the returning officer, then have been given to the returning officer. The returning officer shall, in the presence of the candidates or representatives of the candidate, or not more than 2 counting agents appointed by each candidate, assemble results from polling stations without recounting. So, if you read the judgment of the High Court, it talks about the destruction of ballot boxes and they cannot assemble them and what. That particular provision does not ask for recounting. So the specific provision that deals with whether agents are relevant at the polling station or at the collation center is specifically Regulation 48. Sammy, and if you agree with me, or if you permit me, let me read Regulation 48(2). The non-attendance of the candidate or the polling agent or counting agent of the candidate at the time and place shall not invalidate the act of the thing that is being done. So in this particular circumstances, the 2 reasons adduced by the judge, in reference to the violence and also the absence of them, cannot stand in case of the law. The only supervisory law that is remedying elections in Ghana is CI 127, and it must be applied vividly. Again, Sammy, we made our case very known that the court should revert themselves to certain rulings that were made by the Supreme Court in relation to such matters. We made reference to 2001, 2002, and that was a case in Bogatanga, which was an ex-party of Hawaii Akubu, and we made reference to the rulings of the court. The court indicated that the filing of the petition must be filed within time and not out of time. Okay. Again, we made reference to the June ruling of the Supreme Court in Ernest Kumi's case, which was also an ex-party. The court said and gave us a vivid reading that the approved gazette is the one that was done on the 24th of December, which was done on the 24th of December, which was a source of challenge by the NDC, and they submitted that to the Supreme Court. The Supreme Court pointed to us as a party, the NPP, that the 6th January gazette notification is invalid. The only valid one is the 24th of December. And if you check, the Pandai one was gazetted on the 24th of December, and the page number 8123. And this is very specific. Okay. The court was very succinct on it. Again, the NDC proved to us to the court yesterday when we were there that they actually filed their first petition on the 23rd of December, which was premature. And when our lawyers raised the matter, they quickly withdrew that particular petition. And again, before they could file their substantive case in court, they filed it on the 25th of December. 25th of December. So once this was filed, 25th of January, 25th of January, and the cost, that is the security cost, was paid on the 27th of January, indicating that it is way above the 21 days that the Supreme, the PNDC Law 284 has given, and the Supreme Court has sanctioned and indicated that these are the time limits.
Okay, Haruna, sorry to cut in. We are wasting against time, but sorry to cut in. Now that the Electoral Commission has decided to, organize the rerun on the 30th of December 2025, is the NPP going to the constituency to go and campaign, or you still be in the court challenging the order or the ruling as directed by the Tamale High Court? What is the options for the NPP now? Will you be in Pandai to campaign, or you still want to proceed with the legal process?
We cannot approve it and reprove it. We are in court. Until we exhaust the court procedures, we would not come out to indicate the position. So we would have to follow through the court procedures. One, we have the stay of execution, which judgment will be given on the 18th of December. Then we also have the certiorari application that is before the Supreme Court by way of judicial review, which will also be heard on the 16th of December. Then these two particular cases are the issues that we are going to follow through, get the conclusion of these particular issues, and then the party will decide through the structure of the party, as in NEC or the steering committee will take a decision whether we go or not.
But Haruna, if you agree and you know very well that you won the election on the 7th of December 2024, you just have to go back and reaffirm, that victory which you won in 2024. Is that simple? If you believe that you won the election, why are you afraid to go back to the people who voted for you and say, hey, we are back here, give us another mandate?
Sammy, it's just like a thief taking your money and you have the power to take it from the person. You decide to go and report to the police, and then you see that there is a delay. You decide to go with your own muscles and go and collect the thing from the thief. You have to follow through the law. Once you have reported the matter, it must take the full course of the law for you to get your stolen item back. So we are not going to renege on our effort and say that no, because the Electoral Commission has said what they have said, we are going to abandon. No, we are going to follow the law. Remember that the Electoral Commission in their letter referenced an order of the court and a letter coming from the clerk. There could be an order that is going to the clerk, and that will also run through to the Electoral Commission, and they will still bring out another notice to stop it. So we will follow through the law and make sure that the law works for us. But what is strange in this country is that if we don't take time, Ghana's democracy will not be the same. Sammy, I bet you, if we don't take time and NDC wants to run on this particular route and wants to take on like this, everybody is quiet, the media is quiet, the civil society is quiet, the chiefs are quiet, the National Peace Council, they look like they have swallowed something that they cannot even talk. You look at all the body, everybody is quiet. Everybody is too sad, their silence is too loud. You see, if they allow these things to do, and in the future, that the NPP comes, somebody sits in parliament, we decide to go and say that we are going for petition, we petition against all of them and draw all of them out of parliament.
Okay.
And people will begin to talk.
Okay.
This is not the state.
Okay, Haruna, thank you.
Allow these things to go, this country will not allow all of us.
Okay.
We will not take it, and when we come, we'll do worse than that.
Haruna, thank you. Thank you very much for your time. Haruna Mohammed is Deputy General Secretary of the NPP in charge of operations, obviously unhappy about the decision of the Electoral Commission to conduct fresh elections or rerun the 2024 parliamentary elections in the Kpandai constituency in the northern region. Fred, the NPP obviously is not happy. Obviously.
Not at all. Not at all. Not at all. Haruna has raised several concerns, and yesterday we had the Deputy Director of Elections for the NDC on CNL, who also came to speak about the issue and also argue their facts on the side of the NDC. So both parties still believe they are right. But at the end of the day, what I always say is that the courts would make the final determination. There's the ruling on the stay of execution on the 18th of December at the High Court. That could say that they are staying the decision. Once they stay that decision, the Electoral Commission cannot go ahead on the 30th.
Okay.
If the court says we are not going to stay the decision, it means that the Electoral Commission can go ahead. There's another application at the Supreme Court. I'm not sure, that's on the 16th, which will be held on the 16th of December. We are not sure what the decision of the Supreme Court would be, whether they would hear also that stay, and whether they would stay the proceedings or execution of that particular judgment. So it's not so clear, but at the end of the day, these issues lie in the bosom of the courts to determine and to see and to give the way forward. So I'm sure by the 18th, latest 19th, we'll have known a clear way forward for the December 30 elections, which has been proposed or stated by the Electoral Commission.
But in the face of all what's happening, this is not the first time we are seeing this, right?
Yes.
There's history to this. There's precedent to this.
Yes. There are a lot of precedents. One, to petitions for parliamentary elections. One, other to decisions of the court, which eventually affect a parliamentary seat. So there's been history. It started. Let's keep to the Fourth Republic. It started in 1997.
Okay.
In 1997, after the elections of the 96, there was one particular seat, the Ayawaso West Wagon seat. The Ayawaso West Wagon seat is a seat which is now held by John Dumelo,
constituency.
Your constituency. So after the election of 96, we had two people contest that particular election, George Isaac Amu and Rebecca Adote of the NDC. George was with the NPP. Rebecca Adote was declared winner of that particular election. After she was declared winner, the NPP raised some concerns and went to challenge this particular election results in court. What are the concerns? They are saying that the EC's returning officer initially declared that the NDC candidate, Mrs. Rebecca Adote, declared Rebecca Adote the winner, and the result was gazetted on December 19th, 1996. The NPP candidate, George Isaac Amu, challenged this and providing some evidence indicating that some polling stations were not added, and other polling stations too, in collating the results, there were problems. So they wanted the court to overturn this particular results declared by the Electoral Commission. The High Court heard this particular decision and overturned or declared that the NDC candidate did not win the election.
Okay.
Basically because they agreed with the concerns raised by the NPP candidate, Isaac Amu. So that particular election was annulled. But that particular election was annulled in 2000, the year 2000, getting close to the
end of the tenure of that
December 7th elections and close to the end of the tenure of the parliament. But there was an appeal filed.
Okay.
Once there was an appeal filed, the court had to listen and hear the appeal and also make a determination of the appeal. So this was a process which was ongoing. What was the decision of Parliament at the time? Rebecca Adote at the time was not taken out of Parliament. She was left to stay in Parliament and indeed stay till the end of her tenure. Okay. Eventually, the court ruled that she was not the rightful person. But at the time, she has
already served the 4 years.
But when you go to parliamentary records, because of the decision of the court, it is, you not see her as MP.
Oh, okay.
For Ayawaso West Wagon.
Oh, okay.
But then she served that 4-year period. And when the decision was made by the court, she was not removed because the court, the parliament waited for the process. And also because of the time left, no decision was taken. That is Ayawaso West Wagon. Then we go to Keta.
Keta constituency.
Keta constituency. There's a similar occurrence in Keta, but this time round, the Keta issue did not have to do with an election petition. The Keta issue had to do with the sitting MP at the time, Daniel Abudakpi.
Okay.
What did Daniel Abudakpi do? In February 2007, he was then sitting MP for the area. He was sentenced to a number of years imprisonment.
Okay.
After a long trial. This trial had to do with false pretenses, woefully causing financial loss to the state, amounting to about some $40,000.
Oh, wow.
He was sentenced to 10 years imprisonment. Once he was sentenced, he appealed that particular decision. And in the process of appealing that particular decision, there were concerns with the fact that the MP has been sentenced in prison, he's gone to prison, there's a seat which he holds, and it should be declared vacant. In fact, between the NDC and the NPP at the time, there was a disagreement as to whether his seat should be left till the appeal process is dealt with, or it should be declared vacant because the people of Keta cannot be left without an MP. This was a back and forth. No decision was taken. So Daniel Abudakpi's seat was left without anyone occupying it whilst his appeal process took place.
Okay.
In fact, by the end of the process, it was also up to another election. That was the 2008 election. Dan Abudakpi was granted amnesty anyway, but then within that period, his seat was not declared vacant by Parliament. In fact, there were private citizens who went to court, to the Supreme Court, as far as the Supreme Court, to get the court to declare
the seat vacant.
The processes went on, but as I said, it did not see the light of day because there was the election of 2008. And he, Dan Abudakpi, did not contest. Somebody else contested and won that seat for the NDC. This is another scenario.
Interesting.
So we've seen a scenario from an election petition. We've seen another scenario from a criminal case where the court has given a ruling and the seat is supposed to be declared vacant. But then other judicial and legal processes transpired and what happened in Parliament. The next one would go to the Nkoranza North constituency. The Nkoranza North constituency in the year 2005. So this is after the 2004 elections. Eric Amoatin, I don't know whether you recall.
I remember Eric Amoatin very well.
The member of Parliament at the time for Nkoranza North was Eric Amoatin.
Major Derek Odro replaced him.
Exactly. So Eric Amoatin of the new Patriotic Party, what happened to him? There was a story of how he traveled to the US. He was arrested with allegations at the time of drug trafficking. He was kept there for a very long time. During the period, he was also a member of Parliament, having to represent his people. It became an issue in Parliament, where some of the MPs on the minority side at the time, which was the NDC, also called on the Speaker to trigger the process of removal based on the fact that he was absent. And he was dealing with legal issues outside the jurisdiction of Ghana, which is the United States of America. The majority at the time also argued that you needed to give him space, you needed to give him time, because the person had not been declared guilty or not. It is only after the person is declared guilty that is when you can declare his seat vacant. and he's not able to serve, that is when you can declare his seat vacant. This also triggered some constitutional debate at the time. Whilst others were demanding the by-elections, others said no. Amwate himself wrote to the speaker initially to ask for some time.
Yeah.
And the Privileges Committee at the time gave him a period of time to be able to deal with his issues. After a long while, when he was unable to deal with his issues, or when the court case kept on dragging, he decided to resign. So he wrote a letter to the speaker resigning as MP, which called for a by-election, and as you said, Major Derek Odro took over the seat. So this is, Amwate's case is also another scenario of an MP not being present, dealing with a legal issue and how the House dealt with it. So we've seen Ayawaso West Wagon, we've seen Keta, we've also seen Nkoranza North. It didn't end there. Outside Nkoranza North, there's also another case of an MP and how he dealt with that issue. But Sami, I think that at this point, we'll take a break. When we return, we'll deal with the next two issues, which had to do with MPs who had to deal with court cases and what the orders of the court meant for their seats and whether they remained or stayed. We'll be right back.
I didn't know this assassin. But I said, if one, the whole fashion empire and fear, and I won't hear and anything name fear. That's mean to me, man, and your best way will be to me cool. Mr. Daddy.
Yeah, welcome back, and this is the Situation Room. We've been discussing what's the history of parliamentary seats and the decisions of the court and how it affects or affected the MPs at the time. We've gone through 3 different constituencies, and we are going to our next constituency, which is the Bawku Central constituency. The Bawku Central constituency, which is now the seat occupied by the majority leader, Mahama Yaiga. So in 2004 to 2008, after the 2008 election, Mahama Yaiga went into that election and lost that election to Sakande.
Adamu Dramani
Sakande.
I remember him like yesterday.
Yes.
You know?
After that victory, there was a gentleman who was a farmer, or who is a farmer, who went to court to challenge the election results. Not just the election results, also challenge the
qualification of Adamu Dramani.
Dramani to contest. He said he had a dual citizenship.
A Burkinabe and a British citizen as well.
Hence, he couldn't contest as MP, as required by law. When the case went to the High Court declared that the MP at the time was guilty.
Okay.
That declaration was made by Agnes Doji, who is now a Supreme Court judge. At the time, she was a justice of the High Court.
Okay.
After this declaration, Adamu Sakande had issues with it, went to the Court of Appeal, ended up at the Supreme Court. In fact, at the Supreme Court, there was an order for a retrial. But whilst this was going on, there was the other hand aspect of it, which was the criminal case. The criminal case found Adamu Dramani guilty and jailed him. This was somewhere between 2012, 2011, heading also close to election.
Yeah.
There was the issue of declaring the seat vacant. But then his appeal of the criminal case also kicked in. With the issue of Bawku Central, the timing of the ruling of the court and the timing of the election also did not allow for a by-election. So that seat also was remained empty, not vacant. It wasn't declared vacant. It was empty till the next election. Then the most recent one, Assin North, James
Jachikwesin case.
What happened? Also, someone challenges the results. There's a court case. The High Court declares that he's ineligible to contest, declares the case, the seats vacant, orders that his name should be taken out of the records. There's a court of appeal. There's an appeal at the court of appeal. It ends up at the Supreme Court. The Supreme Court upholds the decision of the High Court and orders that his name be struck out totally from the records of Parliament. But at the time of the High Court's decision, what happened to James Jachikwesin? The majority at the time, which is the NPP, also made moves to declare the seat vacant. Who was the speaker at the time? Alban Bagwin, who was still speaker. He withheld this decision, asked the court processes to go on. The court processes went on. The NDC even had some issues with the entire process. But eventually, when the Supreme Court, the final court of adjudicature, made a decision, his seat was declared vacant and a by-election was held. He came back to Parliament by winning a by-election. So you look at the history, and you realize that for a very long time, when it comes to MPs and courts' decisions, usually, per the history, they wait for the processes to play out in court
before a declaration
is made. But this time round, there's a different interpretation, and we are sure that the court itself would give a clear direction as to what is right and what is wrong.
His name is Fred Jabon. Sami, we have brought you another exciting edition of The Situation that came to you live from our studios here in Accra. So we'll come your way again. May the good Lord be with us all.